Thank you very much to Ro, and I'm sure we all hope she gets well soon. And finally, I'd like to introduce Emeritus Professor Gillian Triggs, who will conclude today's opening plenary with our first keynote address at the conference titled LGBTI Human Rights in a Post-Truth Age. For those of you who don't know Professor Triggs, she is the former President of the Australian Human Rights Commission. Prior to that increasingly public appointment, Professor Triggs was the Dean of the Faculty of Law and Challis Professor of International Law at the University of Sydney, Director of the British Institute of International and Comparative Law, and former Governor of the College of Law. Professor Triggs is also a highly respected academic, author and expert on international commercial legal practice and human rights law. Professor Triggs is currently a Senior Fellow at the University of Melbourne Law School. On behalf of all the conference delegates, it is a real pleasure and a privilege to welcome you to the stage, Professor Gillian Triggs.
Well, it's absolutely fantastic to be here today. What a group and what warmth and enthusiasm. I couldn't be happier to be here myself. And I'm even more delighted that we have moved back to the equality state. I've been in Sydney for the last 10 years, but I can tell you Victoria is the place to be if you're going to think about equality. And I think in particular I was very impressed by the words of the Minister Sharon Knight. How lucky are we in Victoria to have somebody with such a strong background in social justice, who really understands the issues, has worked at the grassroots level and is articulate as she is. Auntie Di, thank you very much for your welcome to country. In fact, in your short speech, you made many comments that I think qualify you to being a Human Rights Commissioner in Australia. You mentioned everything that's important to me, equality of rights, but as is so often the case for our Indigenous peoples in Australia, you seem to have the wisdom and the language that's so important, and talking about travelling together is really a key point, and you understood that so well. So I too, of course, acknowledge the traditional owners of the land, the peoples of the Kulin Nation, and respect any of their elders in particular who are here today. Well, I was delighted to come to this, or to be invited to speak to you today, and I bring, I hope, two perspectives to this conference. The first is that I'm over 70, and thus personally interested in how an older person can hope to be treated with equality and with care. Well, Oscar Wilde said, "A woman who'll tell you her age will tell you anything." Well, I'm not going to tell you everything, but I will say that as an older woman, I'm increasingly alert to the vulnerabilities of older people generally, and to the particular vulnerabilities of those who are lesbian, gay, bisexual, transsexual, and intersex. And perhaps following on the story that Auntie Di gave, I also have a little bit of a story, because when I first joined the Commission as the President of the Human Rights Commission, I decided that it was time, not just about time, but time, that the Commission came out and recognised the needs for equality before the law for all Australians, and in particular that the Commission should support marriage equality. And when I went home that night, I got an email from somebody to say they hadn't realised that I'd not come out before, and that they were very pleased that I was lesbian. And I thought, well, I'm not actually. And what if people think that because as President I supported this initiative, I was gay? And then I thought, what a stupid thing to be worried about. In any event, who could care about the sexual orientation of an over 70-year-old woman? So that got me over that little hurdle. But the second thing that I hope that I bring to the conference today is a human rights law perspective. The LGBTI community have a right to respect, to dignity, and most importantly, to personal autonomy. There are many perspectives on LGBTI issues that one could talk about: medical, mental and physical well-being, cultural, issues of housing, employment, aged care that we're going to talk about today, and financial matters. But for me, and from my perspective, it's absolutely imperative that we have enforceable legal rights that provide the vital framework for all LGBTI needs. And one example, and I hope you're familiar with it, you probably are, was the very important Toonan case from Tasmania, where, as you'll recall, Tasmania had maintained a criminal prosecution for homosexual acts. A disgraceful position, and a very unusual one in that it was the only state with that criminal prosecution, and the Commonwealth government wanted to do something about it, but didn't know how to go about it. And what happened was, as you'll remember, in the Toonan case, the Toonan went straight to the Human Rights Committee, part of the United Nations human rights law structure of complaints. And that committee said, and it was a rather odd legal outcome, but what the committee said was that there's an Article 17 of the International Covenant on Civil and Political Rights that protects the right to privacy. And that right to privacy meant that the acts in private of consenting adults could not be criminal as a matter of international law. And that gave the Commonwealth the constitutional power to come back in and to, with conflicting laws, outlawing those kinds of prohibitions, and that set the legal foundation for recognising the equality of all LGBTI community in Australia. Now, it's a convoluted way of getting to the right answer, but as an international lawyer, it interested me that that's how the breakthrough came in ending the disgraceful maintenance of those criminal laws that led to the kinds of discrimination that we're still battling with today. Well, in concluding my term as President of the Australian Human Rights Commission, and I should say I was introduced as Emeritus Professor, I was told by a friend not very long ago in an introduction, an erstwhile friend, that Emeritus is Latin for has-been. Well, I'm not quite a has-been, and I'm still going strong. But I can make the observation, having had a couple of months now to stand back from my position as President, to make the rather startling but true observation that in almost every area of our human rights work at the Commission, the LGBTI community suffers higher levels of discrimination than other members of the Australian community. And that included the work on disabilities, particularly disabilities, actually, asylum seekers and refugees, the aged, children, juveniles, domestic violence issues, employment discrimination, and even sexual harassment and assault within the 39 Australian universities. It's an extraordinary phenomenon, but all the work that the Commission does is based on research. We cannot afford the anecdote or the story, and we certainly can't afford to get anything wrong. If we do, then we're, as you well know, pilloried in the media for any mistake. We can't afford it. So the research that we do had to be impeccable, and all the research that underpinned everything we were doing, whether it was for the Army and the armed forces, which we could not say a great deal about, and all the way through asylum seeker issues, employment, the right to work, and ultimately the most recent work on sexual assault and harassments in universities. In every one of those areas, discrimination against the LGBTI community was one of the highest, if not the highest level of discrimination. It's really quite a shocking feature, but when you build this factual work, this research together, you see a pattern that is a disgraceful one. It's more hidden, it's not always well known, but I think conferences of this kind bring these issues to the fore. Well, it's quite clear that LGBTI people face a range of challenges in Australia: poor community understanding and visibility of the distinct issues that affect people on the basis of their LGBTI status, state-sanctioned structural discrimination, which has flow-on impacts in legitimising institutional and interpersonal discrimination, a lack of cultural competency, and that's been mentioned, and an understanding of the distinct needs of the LGBTI community in the provision of public services. Now, that criticism I don't think is applying to Victoria, but it certainly, I can tell you, applies throughout the rest of Australia, but particularly in education, healthcare, and aged care. But also attitudes from people of different cultural backgrounds that have a negative view of LGBT rights and their issues, particularly the Safe Schools program, affecting children during the developmental stage of their life, is particularly troubling. A response to a program that in fact was rational, caring, based on evidence, and vitally important. That it should have been criticised in the ways that it has is another national disgrace. Well, the experience of unjust discrimination then remains a key barrier in advancing a culture of respect for LGBTI people. Removing that unjust discrimination is vital to ensuring that LGBTI people feel confident to realise their full potential and to maximise their contribution to Australian society. Now, what I'd like to do, if I may, is to show you a video. It's not particularly about LGBTI, and it's not particularly about aged care, but it gives you an idea of the kind of work that the Commission is doing and the enormous importance of visual video communications. And I think the Blue Care one was an extremely moving and important educational tools. And so I'd just like you to look at this one. It also uses humour, I think, quite well, and that's a great weapon I have discovered in trying to get across these key ideas. So if we could have the video, please.
I know what you're thinking. I'm old, very old. And you might be wondering, how did I get so lucky? Because, as you and I know, old people can do amazing things. We're experienced, and we know how things work. We help in our communities in ways big and small. We're active in life and online. We add billions to the economy. And when it comes to the tough choices, we've got the wisdom to get it right. Oldness, it's everywhere. And if you're lucky, it can happen to you.
Sorry, sir. We're looking for someone younger.
So that's just an indication of the kind of work that we're trying to pull money together to create these kinds of educational tools that have got a bit of humour, but actually pack a punch at the end. My only criticism of that video is that the hero looks to me to be so young. So I think we got that bit wrong. we can redo it. Well, now, and I don't want to bore you all too much with the law, but it is where I come from, and it is what I think underpins everything that you're trying to achieve. So I would like to go through just a little bit of the legal structure. Firstly, to begin with the International Covenant on Civil and Political Rights, one of the most fundamental underlying principles of international human rights law, something that Australia at that time in the 70s played such a strong role in negotiating and ultimately signing and ratifying, but which is not part of Australian law. It's part of the mandate for the Commission, but it's not part of Australian law. But nonetheless, it underpins what I want to say, because it provides in Article 26 that all persons are equal before the law and entitled without any discrimination to the equal protection of the law. That is a fundamental provision, and it says the law shall prohibit any discrimination and guarantee to all persons equal and effective protection against discrimination on any ground such as race, colour, sex, language, religion, political or other opinion, national or social origin, property, birth or other status. Now, that doesn't deal directly with the issue of sexual orientation, but the law has subsequently been interpreted by that very same committee, the Human Rights Committee, that looked at the Toonan case, that the words other status includes sexual orientation. And this is how the law develops, but these were very, very early days. But let's have a look. I'd like to begin with age discrimination and then move on to the protections for sexual orientation. There's no international convention on the rights of the aged, although it is important to recognise that Australia really has led the way with national legislation on age discrimination. That doesn't exist in many countries in the world, and my wonderful colleague, whom I'm sure you know, she was the former Minister and Senator Susan Ryan, has really pushed for that legislation and is now pushing for an international convention for the protection of the rights of the aged. We have UN principles, but not a convention, on older people, that older people should be able to live in dignity and security and be free of exploitation and physical and mental abuse, that they should be treated fairly regardless of their sexual status, and that they should have autonomy to enable them to achieve independence, participation and self-fulfilment. In particular, the National Age Discrimination Act makes it, and this is relevant particularly for today, unlawful to discriminate against a person on the basis of their age by refusing them accommodation or discriminatory terms and conditions for that accommodation. We also have a growing interest in aspects of ageing that are particularly troubling in the current society, the phenomenon of elder abuse. And you might have noticed that the federal government has marked the International Day of Older Persons by announcing a range of initiatives to better protect older Australians. A survey conducted by the State Trustees of Victoria found that 1 in 5 people knew someone who'd been a victim of financial abuse, the vast majority of perpetrators being a family member. The Australian Law Reform Commission has gathered evidence of serious physical abuse, neglect and exploitation of older people, and the Attorney General, George Brandis, has responded to this evidence by saying that the government will now establish an elder abuse peak body to fund more research into the extent of the problem. The problem does seem to be a very significant one, with the Australian population over 65 expected to rise to 23% of the entire population by 2055. Then we clearly have to start thinking about it. The Elder Abuse Inquiry by the Australian Law Reform Commission has been timely. The Australian population, like other developed countries, is an ageing one. The combination of life expectancy and lower fertilities levels mean that we have this rising ageing population. It's something that's very well known. But we also have an inescapable picture of elder abuse. And the Australian Institute for Family Studies identified financial abuse as accounting for 40% of the most commonly reported type of abuse, and the largest group of offenders being children in their 50s. It's a rather shocking phenomenon. And there are so many intersections in this area. The phenomenon is that women are typically the carers and unpaid carers of older Australians, but typically they're going to be in that 55-year-old age group, and they are going to be the perpetrators of this kind of abuse, which is a rather tough thing to acknowledge, but it is statistically true. It's true also that there are many angel sons and angel daughters who, of course, should not be punished by this rising information about elder abuse. But it is a very significant problem, and it's one that I think I'm pleased to see that the government has taken up. But the other element to today's conference that's critical is not only the rights of the aged persons, which is emerging as an area and a greater understanding of healthcare needs and the phenomenon of elder abuse, is the protections provided under the Sex Discrimination Act. That, again, interestingly, was promoted by Susan Ryan. She suffered a great deal of opprobrium in the early 80s when the Sex Discrimination Act was drafted. It was intended, of course, and did give effect to the Convention on Sex Discrimination. And it's been one of the most powerful and successful forms of protection for human rights in Australia. Insofar as LGBTI is concerned, importantly, the Sex Discrimination Act does explicitly protect sexual orientation. And an area that's relevant to aged care is the Section 22 on goods and services under the Sex Discrimination Act. It's unlawful for a person who provides goods and services to discriminate on the basis of that person's sex or sexual orientation. And similarly, that applies in relation not only to goods and services, but to the provision of accommodation. So the law is there in relation to those issues, but perhaps not always understood and not always applied. But I'd like now, if I may, to move on to the issue that, of course, everybody is talking about, and so they should, which is the postal vote for marriage equality and the phenomenon, really, of post-truth which troubles me particularly. I've mentioned how important it is that we have accurate research for everything that we do. What is troubling is that there is a phenomenon globally, but including Australia, in which the facts and evidence are increasingly being ignored for subjective, entrenched views. And there's a very interesting research done on the year leading up to the election of Mr. Trump as president by a colleague of mine. She's the dean at Harvard School of Government, and she embarked on a study to determine to what extent do facts really matter. And she's written a book called Do Facts Matter? Now, she didn't know the outcome, although perhaps she suspected it. But a year later, culminating just after the Trump election, she concluded that the facts do not matter if you have an entrenched, ill-informed and subjective point of view. And that's very worrying for somebody like me, because I rely on accurate statements of the law and accurate statements of the facts and research. And when that's not important, and that people are so entrenched in their views, then this creates a problem that we've got to be much more proactive in dealing with. Well, I begin, of course, in relation to marriage equality, as I said earlier, that it's a question of equality before the law. There's no doubt, in my view, that the fundamental provisions of the International Covenant on Civil and Political Rights on equality before the law provide the legal foundation for where we want to take this debate. But we also have important comparative jurisprudence, particularly from the United States Supreme Court in the Obergefell case. Some of you will have read that decision. But very, very interesting and a point of difference between Australia and the United States. Because there's a Bill of Rights, or there are Bill of Rights provisions in the United States Constitution, and in particular a provision on equality before the law, it was possible to take, in this case, the Obergefell demand that he be given the right to marriage equality all the way to the United States Supreme Court. And that court said, based on historical movement of law, from the times when marrying across different races was illegal, when contraception was illegal, when women have very few rights, the Supreme Court, and a relatively conservative Supreme Court, nonetheless said, the law moves, the law changes, and we now recognise the principle of equality before the law, and as a Supreme Court determination, every state in the United States must allow and recognise marriage equality. And that was a very, very powerful decision. Now, we can't achieve that result in Australia because we do not have Bill of Rights provisions, as we should, and we do not have fundamental provisions like the International Covenant on Civil and Political Rights as directly part of our Australian law. So to go to the High Court on this question was never going to deliver the result that was required. What we needed was a vote in Parliament from our elected representatives to reach that result of equality before the law. Now, shamefully, in my view, Parliament has failed to do that. The politics have simply become too difficult, and we now have a bypassing of the political and legislative processes to a process of a postal vote. But my purpose in raising this today is to talk about the problem of post-truth, of where we are not really concentrating on what is the truth, what is the law, and what are the facts. And I find this very troubling in the context of the mischievous diversion of the debate in terms of the right to freedom of religious expression. I've heard almost nobody mention the fact that despite what I've said about us not having a Bill of Rights in Australia, which is true, and most of our human rights are not protected by the Constitution, the right to free exercise of any religion is protected by the Australian Constitution under Section 116. That prohibits the Commonwealth from making any law which prohibits the free exercise of any religion. Now, that provision is seen by scholars in the field as close to an absolute protection from coercive laws. In short, the Commonwealth cannot compel conduct that contravenes a religious belief. By contrast, you can burden religious practices with certain provisions, so that in an older case, Krieger's case, the compulsory peacetime military training could be enforced upon people despite their religious views. So there can be burdens. The question then is, to what extent will a yes vote for marriage equality burden the right to freedom of religious expression? And the answer is it will not. And the sex discrimination in particular makes it unlawful to discriminate on grounds of sexual orientation, as I've said, but it includes numerous exceptions that protect religious organisations, in particular education and selection of ministers and priests, and it protects all sorts of things, employment of people of different sexual orientation will be protected for religious organisations, and they have been protected for decades without any public debate about the issue. But perhaps I could mention one in particular, which is hardly understood within the Australian population and which was passed about 5 years ago with very little public debate. I've said that the Sex Discrimination prohibits discrimination, the Sex Discrimination Act prohibits discrimination, and there are religious exceptions that protect religious organisations where the Act is one that reflects the tenets of religion. But now, if you can hold on to your seats, there's an exception to the exception. Indeed, indeed. And what this does is that the protection for religious bodies does not apply if you are providing aged care facilities with public funds. Now, when I first saw that draft introduced by the Labour Party at the Commonwealth level, I thought it's going to create a furore in the public arena and it's never going to get through. It's going to be far too controversial. We did our own research and we saw that those groups that actually provide aged care facility, of something like 65% of them, are faith-based organisations. And that's a very important thing to recognise. And we value them for that reason, among many others. But also, if they are receiving public funding as they are, they come into the public arena, they should apply or be subject to the same laws that everybody else is subject to. But it seemed very controversial. And we did our research. We went to the Catholics, to the Uniting Church, to the Anglican Church, to the Jewish community, and so on. And we found over and over again that the answer was we would not discriminate against same-sex couples in providing aged care facilities. And if we're receiving public funding, we accept that we should abide by the laws that apply to everybody else. So there were one or two exceptions that I won't mention at the very senior levels of a particular church, but nonetheless, broadly speaking, there was an acceptance that this was a fair provision. And to our complete astonishment, while the consolidation bill introduced, was to be introduced by the Labour Party, fell apart, the one provision that survived was this one, the exception to the exception. Absolutely extraordinary. I'm really delighted, but it's extremely relevant, highly relevant for today's conference, because it makes the point that at least in the public arena, if you're offering a public service and you're receiving public funds, then you must comply with the general law of anti-discrimination law. But I can assure you that protection for religious views is very clearly there in the Australian Constitution. And as I was mentioning the Obergefell case, this is one of those areas where you can, in fact, proceed to the High Court of Australia to get the right answer. And I think we need to be more alert to that, because it worries me that there's so much misinformation about the right to freedom of religion that is distorting the current debate. Questions like sex education in schools. It's very likely that marriage equality and sexual orientation would and should be included in education in schools. I have no difficulty whatever, but that's a reflection not necessarily of a change to the Marriage Act, but as a reflection of evolving community standards. Now, it must be conceded, and I need to make this point, that the protection for religious freedoms exists for organisations, but it doesn't exist for individuals. In other words, individuals can be burdened by the need to comply with marriage equality laws if they are passed, and I believe they will be. But we do come back to this extraordinarily banal problem of people who don't want to bake cakes for same-sex marriages. I cannot believe that the complexity of this area gets down to such an utterly silly issue. I heard Penny Wong speaking about this, and I think she's absolutely right. She said the marketplace will take care of this. You do not need the law, and there's a limit to how much the law can intervene. You do not need the law. Anybody who has a sign up saying they'll bake cakes for anybody except the LGBTI community can expect to have a very small and diminishing business. But the upshot is, although we don't yet know what legislation will be introduced, and nor can we in a case like this. If you're going to have a plebiscite of any kind, it's got to be a simple question. If you had the entire legislative bill in front of the public, you'd never get an agreement on anything. So I do appreciate that. But we will eventually see what that legislation is going to look like. But I think it's very unlikely that it will protect individual purveyors of services like reception centres and cakes and weddings and wedding paraphernalia. So I think it's a furphy, but it builds into my problem of dealing constantly with this concept of post-truth, of distorting a very simple idea of access to civil marriage for all Australians does not interfere in any way with religious faith-based practices. And we wouldn't want to interfere with those practices in the context of the marriage ceremony. The last thing I thought I'd mention is freedom of speech. People are saying that if you speak up against the marriage equality, against the current marriage equality provision, if it were to be successful, that will impinge on the right to freedom of speech. This is absolute, unmitigated nonsense. And a very good example is that many decades ago we ended fault-based divorce, but churches can still preach in favour of their own views in relation to divorce. But we don't bring these people before the courts and prosecute them for breaches of various provisions of state and Commonwealth legislation. But I think you can see that some of the points I'm making are not ones that are easily made in the public arena. Unfortunately, in this era of post-truth, we need slogans. We need short, sharp, clear statements. And I think we've really got to stick to the idea that this is about civil marriage and equality before the law. And I think Australians pretty much get that. Well, I should conclude, and it's been a privilege for me to have such an opportunity to develop some of these ideas that I think are important. I think we will get there with this postal survey, inappropriate as it is, and contrary to all of Australian practice. I'm deeply concerned about it as a human rights lawyer because we do not go to the streets or to postal votes on fundamental human rights. It's an absolute disgrace that we're doing it. It's a failure of our democratic process, but it's where we are. And I'm enormously encouraged, regardless of how people have voted, I'm enormously encouraged that apparently 60% of those, or approximately 60% of those postal votes have been returned. I suspect the outcome will be a very positive one, but I'm deeply respectful of the fact that people have decided to be part of this exercise, inappropriate though it is. So, congratulations on this conference. I think it's a fantastic environment, great buzz in the room, lots to talk about, and I think we're on the path to achieving that equality that we care so much for. Thank you very much.